Wow, just 2 seconds ago, I saw my neighbor's wife punch my neighbor right in the nose. Is that statement inadmissible as hearsay, or does it fall within the present sense exception? Let's find out. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Today, we're going to look at the present sense impression exception to the hearsay rule. It is found in Federal Rule of Evidence 8031. This exception allows certain out of court statements to be admissible in court, even though they are technically hearsay. Up front, I want to tell you that this exception is frequently confused with the excited utterance exception, but I'll explain where they're different. So let's revisit first what hearsay is. As I said the other day, hearsay is an out of court statement offered to prove the truth of the matter asserted. Generally, hearsay is inadmissible because the declarant isn't present for cross examination, and that raises concerns about reliability. More currently, the Supreme Court has said it also raises problems with regard to the Confrontation Clause of the Sixth Amendment. 8031 provides an exception for the present sense impressions, and according to the rule, it is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. So there are a couple of things here. First of all, the statement has to describe or explain an event or condition, like, wow, I just saw my neighbor's wife punch her husband. And it has to be made at or immediately after the declarant saw it. So if I had indeed seen that and come in here immediately and put that on video, it might very well have fit within the exception. But a delay, even sometimes as short as 5 minutes, can often mean that you don't get to put the evidence in. If I called you immediately after that happened and told you that, or if it happened while I was on the phone talking to you, you could probably testify to my present sense impression in a criminal case brought against my neighbor's wife. But keep in mind, she has a wicked right jab. The exception is grounded in the belief that statements made contemporaneously with an event are less likely to be fabricated, as there's little time for reflection or deceit. Keep in mind, again, while the rule says the availability of the declarant is immaterial, recent cases from SCOTUS have required the declarant to be available if the gestalt of the statement is testimonial. The definition of testimonial is still a little bit vague, and the present sense impression is not something that was well known at the time of the founding. So let's look at a couple of hypotheticals here. Imagine a scenario where a witness is on a live phone call, maybe a Zoom meeting, and says, "A red truck just ran a red light and hit a white car." That statement is made during the event, describing what the witness perceives in real time. Under Rule 8031, this could be admissible as a present sense impression. It could certainly come in during a civil trial, but it might be challenged in a criminal trial on confrontation grounds unless the witness was available to testify. Now consider a different scenario. The same witness sees the accident, but doesn't mention it until 2 days later, stating, "Earlier today, a red truck ran a red light and hit a white car." That delay in the statement, it taking hours to get it recorded, that lacks the immediacy required for a present sense impression and would likely be inadmissible under the rule. That makes sense when you think about it, because if I had sat here and thought, well, that red car, that might very well have been my good friend Jim, and I don't want to testify against him, so maybe I'll say it was the white car, that kind of thing. If you have time to think about how you might better serve someone with your statement or get somebody in trouble with your statement, then it lacks the immediacy required for a present sense impression, and it's going to fall under Rule 8031. In State versus Little, a North Carolina case involving two men who engaged in a shooting outside of a gas station, a state investigator interviewed an eyewitness to the event. Little, who alleged that he only drove the shooter, Owen, to the gas station, disclaimed any agency in the attack. I didn't have anything to do with it. I don't know what they're talking about. At his trial, he wanted to get in the witness's testimony recorded by the state investigator. And that's because the victim who was shot had said that the co-conspirator, Bruce Owen, had fired the shots. The eyewitness was interviewed hours after the event, even though the statement was made by the victim to the witness immediately after the shooting. The length of time between the victim telling the witness was fine, but the length of time between the witness telling the investigator was not. So that hearsay statement did not come in. Now let's look at a successful application of the exception in United States versus Murillo, 288 F. 3rd 1126. It's a Ninth Circuit 2002 case. So again, this was decided prior to the Crawford case, and it doesn't really have anything about the right to confront in here. In that case, the court admitted a statement made by a murder victim during a phone call describing her companions at the time. The court wrote, on the night of her murder, Margello called McGuigan from the Del Mar Motel and told him she was with Murillo and Hironaga. The government moved in limine to admit Margello's statement to McGuigan as a present sense impression under Federal Rule of Evidence 8031. This rule allows the admission of statements describing or explaining an event or condition made at the time or immediately thereafter. The declarant, but not the witness who overhears the declarant, must have personal knowledge of the events. And they cited to a case called Bemis versus Edwards, a 1995 case. The court held that the statement qualified as a present sense impression because it was made while the event was unfolding and it ensured its reliability. Note that this exception does not require that either the declarant or the witness be excited. It requires temporal linkage such that there was insufficient time for the witness to engage in deception. And again, keep in mind that in criminal cases, you now have this confrontation issue that I talked about yesterday, and that's important because in this case, that case was not on the books. I can see a pretty huge problem with trying to admit this now, given the failure or the inability to confront the witness. This would appear to fall directly under the Giles case, where if the person wasn't made unavailable specifically to keep them from testifying, then it stays out. So again, one of the things I talk about quite frequently is that case law changes and new rules get developed. And it's worth noting that in spite of the changes in 2004 and 2008 at the Supreme Court, the federal rules of evidence have not been amended or changed to include these concepts of confrontation under the Sixth Amendment. So here are the key takeaways. To summarize, a statement to qualify as a present sense impression under Rule 8031 must be made during or immediately after the event. It should describe or explain the event or condition, and the declarant must have directly perceived the event. Understanding these criteria help determine the admissibility of such statements in court. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.